So, good evening, everyone. I'm Kumar Rishabh, and with me is Arush Agarwal. We both will be the moderators for today's session, and we have our esteemed panelists with us connected. Mr. Steve Ngo. Professor Steve Ngo is the president of the Beihai Asia International Arbitration Center in Singapore, and our international arbitrator, academic, and arbitration specialist. He is also known for the chairs. He also chairs the Arbitration and Dispute Resolution Practice Interest Group of Asian Legal Alliance Platform. Additionally, he is the chief advisor of Myanmar International Arbitration Center (AAICDR) Asia Advisory Committee member and council member of Hong Kong International Mediation Center. And then we have Mr. Shaun Pereira. He is the associate from Shearman Sterling from Singapore Group. And he's one of the renowned faces in the ADR sector. Then we have Mr. Angad Sandhu with us. He is the partner at PSL Chambers and one of the renowned faces in the ADR sector and arbitration field. With us, we have Mr. Nivesh Sharma. He's the founding partner at Prudens Globus Legal Solution. Moreover, he's an alumnus of NLU Delhi in competition law, and he has also been a research associate at Indian Institute of Corporate Affairs. So we welcome you all with us, that you guys have taken out your precious time and have helped us to impart knowledge in the field of ADR. Thank you so much, sir. Thank you so much. So today we are going to discuss upon first of all, we are going to discuss upon the efficient ways and strategies to conduct a virtual hearing, as in the time of COVID, there has been a halt on the recent hearing, on the remote hearings. So we have decided to have a session on how to conduct an efficient and what all strategies can be followed to conduct a virtual hearing. So first of all, I would like to tell about the format of the webinar. Each and every panelist will have their opening remarks in 5 to 6 minutes, and then we'll be moving forward with the subtopics inside this particular agenda. Then we'll be moving with the questions from the audience and with the concluding remarks. I hope it is clear with everyone, sir. And let's move forward with Arush. Arush, do you have something to speak upon?
Yes. As the COVID pandemic outbreak, there are only 4 methods that we can see that may or can be followed. First is there can be a delay in the proceedings. Second is that it can be in the written form. Third is a virtual platform that we can follow. And fourth is a hybrid mixture of the written and a remote follows. So for the opening remarks, first I'd like to call Mr. Shaun Pereira, sir, to give his opening remarks on how we can efficiently hold a virtual hearing.
Thanks so much, Kumar, Arush, and thank you so much for inviting me to participate in this this session. Maybe I'll start with a bit about myself. I'm based in Singapore. I'm part of Shearman Sterling's International Arbitration Group. I've been in practice for about 7 years. The first 4 of those 7 years I spent in the Supreme Court of Singapore. For 2 years, I was a law clerk to the justices in the Supreme Court. And then for the next 2 years, I was an assistant registrar magistrate in the Singapore High Court, and I also assisted with cases in the Singapore International Commercial Court. So that was about 4 years I spent in the court and, steeped in a way in the litigation process, doing hearings. And then for the past 3 years, I've been with Shearman Sterling's international arbitration practice. And we've done, mostly international arbitration work. I've been fortunate to have the opportunity to work in the offices in Hong Kong and in New York. But I spent most of my time here in Singapore, where I'm from. So, as part of my opening remarks, and Kumar, Arush, I'm not sure how you envisage this session to be, but I suppose it would be more sort of interactive, and most of the meat of the session would be in the discussion that follows and the questions and answers. So I think I'll keep my opening remarks short. And then we can pick up the points as they come up in the discussion and in the questions. I mean, the topic is pretty broad, right? Conducting a virtual hearing, but I would say that the considerations that arise can be grouped into 4 broad categories. And I'm just going to give that, and I think it's just helpful as an analytical framework as we approach the topic, to just kind of set out how I've thought about the discussion and how this might pan out. The first thing I think one needs to think about is the legal framework, right? That supports the virtual hearing. I mean, you may have situations where it's a court proceeding, and the court rules or practice directions should make clear what is permitted or what is permissible. But when it comes to having a virtual hearing in an arbitration, there are a few more layers you need to think about, right? So do the arbitration rules permit a virtual or remote hearing? Do the parties, arbitration is consensual, so do the parties need to consent to the virtual hearing? What if the parties disagree? Can the tribunal make a direction for a virtual hearing above the parties' disagreements? There have been some rules, there's been some views saying that the ICC rules, for example, Article 25 requires an in-person hearing unless the parties have agreed otherwise. That because a virtual hearing may necessarily span across multiple jurisdictions or geographies, I think one needs also to consider the potentially applicable laws. For example, if a witness is giving evidence by video conference from another country, do we need to consider whether those other countries' rules or laws permit the giving of evidence by video conference? If so, what are those rules, and how do we make sure that the witness is complying with them? Right, so this is the first broad topic of considerations I think one must turn to, the legal framework against which the virtual hearing is conducted. The second of the 4 broad topics I think one needs to bear in mind are the case management considerations, right? So for example, if we are going to have a virtual hearing, how would that affect the directions that you're giving in the cases? Would you, for example, try and narrow the scope of oral examination by allowing the parties, rights of written reply in their witness statements and affidavits, so that, you really narrow the areas of factual dispute for the purposes of oral examination? Do you try and structure your directions so that there's a greater focus on written advocacy rather than oral advocacy? More rounds of submissions, more detailed submissions? Do you adopt a more a more aggressive approach to case management? Do you try and make sure your directions crystallize the issues, focus the parties on the key areas in dispute as opposed to how you would do it if you are having a physical hearing? So I think this is the second broad category of considerations that one needs to bear in mind, case management considerations. The third of these 4 broad topics, and I'm really just kind of laying them out in a very general way, and we can get into the meat of these as we discuss. The third of these is practical considerations, right? There are issues like the technical capabilities of, the various parties, cyber security issues. How are we going to exchange documents? Are the documents going to be exchanged in virtual format, or are they going to be exchanged in paper format? How are we going to conduct the hearing? Would it be a fully remote hearing in the sense that the witness is in one place in their home somewhere, the legal teams are each in their homes, the tribunals are each in their homes? Or do we have a kind of hybrid situation where the legal teams and witnesses of one party are in one physical hearing location? And how does that affect the conduct of the proceedings? How do we ensure that, the integrity of the process, right? How do we make sure that the witnesses are not getting assistance in any way when they're giving their oral evidence, right? So these are the sort of practical considerations that one must bear in mind when you're talking about virtual hearing. And this is the third category. And the fourth one, and I'm going to come really quickly onto it, is just, the specific points to bear in mind when you come to the actual conduct of the hearing. Are there specific things you should think about when you are having submissions, when you're cross-examining, when you're referring the tribunal or the witness to documents? What are certain best practices you have in the actual conduct of the virtual hearing? And yes, so those are the four kind of main topics that I thought would sort of arise from the question of, the efficient conduct of the virtual hearing. And, I'm very happy to hear anyone else's views or thoughts on these issues. Thank you.
Okay, sir. So moving forward, Mr. Angad Sandhu, sir, do you wish to add something to this particular point of Shaun, sir?
I think what Shaun said, just building a little bit upon what he said, I'm in complete agreement with him. I actually got to dabble in virtual hearings sometime last year. We did an emergency arbitration under the SIAC rules, where one party joined in remotely. Now, obviously, being an emergency procedure, expedited 14 days, there wasn't cross-examination, there was nothing. It was basically memorial systems, and then straight away we went to a final hearing. But now with the pandemic coming in and changes being brought in by the judiciary and obviously in international arbitration, they are different. The main problem that I probably see with this is cross-examination of witnesses. And as Shaun touched upon that, it's very important to be present, just to read the witness, to see his body language, to be able to probably connect. Mr. Salve, in fact, in a recent interview with the SIAC, said the very same thing. It's about connecting to the witness, and that's the key of a cross. On reading him, seeing how you can, doing that over a video conference is actually slightly problematic. It is. We were recently doing an arbitration under the ICC rules in Doha. We were supposed to be there. Both parties had to log on and do the entire arbitration remotely. The problems that Shaun faced, because it wasn't meant to be a memorial system, because it was supposed to be a physical hearing. There was supposed to be witnesses present. With the pandemic coming in, the cross-examination days the PO was amended, the cross-examination was extended. So it really did throw a monkey wrench into the entire arbitration. And this was a massive dispute with 3 arbitrators present, 1 German company, 1 Middle Eastern company. So I think it's all about learning on the go. We have to evolve with this new reality that we're faced with. And probably none of us at this stage have all the answers, especially when it comes to procedural hearings, when it comes to probably witness examinations, when it comes to actually how you show that there's no one hiding under the chair of the witness and murmuring and prompting him to answer the certain questions that he's faced with. So these small problems that we face, so what we ended up doing was we asked all the parties to arrange a full-length mirror behind them. And we made them sit with the laptop in front of the mirror so the arbitrators could see what's happening in the room as well as what's going on his laptop. So he couldn't, access WhatsApp and maybe see what the answers is. No one could prompt him. Full marks for ingenuity, I guess, for the tribunal to suggest that. But it wasn't the most convenient manner to carry out a cross-examination. But we all have to adopt, and I think it's the new reality. So it's great to be a part of this entire discussion with such esteemed panel members to probably, help others understand and probably help us learn as well on what we could do to make this a more, more seamless hearing and probably a perfect alternative to a physical hearing.
Right, sir. So, Professor Steve NGO, sir, as everyone has a few concern about the integrity of the process, do you wish to add something to this particular point, sir?
Hi, first of all, can you all hear me?
Right, sir.
Yeah.
Yes.
There seems to be some issue here in my video, so I think, all right, it's back now. Okay, no, it's not. This is exactly the issue with technology, isn't it? This is what the one is just concerned because we didn't have a trial run before that. Okay, so if you can hear me, I will just proceed with the video. First of all, I have not been told about the format of today's presentation, so I have prepared a short note of about 5 to 8 minutes to address participants. First thing first, my family name is NGO, it's pronounced as more. It's not a short form for anything else, so in case that helps you in terms of pronouncing my name instead of reading it out as NGO. And right, like Mr. Pereira, I'm from Singapore. I think indeed it is partly technology and partly human acceptance that we can do this webinar today on the topic on virtual hearing. I'm located in Singapore, Mr. Pereira as well, as I was given to understand is from Singapore. And of course, with the majority of the participants are in India. I suppose a year ago, we would not even have imagined the vast numbers of webinars organized and participated last few months during this ongoing pandemic. And I thought today's webinar's topic is somewhat cryptic and also somewhat mischievous because it talks about the strategies to run and promote virtual hearing. The immediate questions are strategies by who and for who. What does it actually mean by running an effective virtual hearing, and who is promoting it? With the team in mind, what I attempt to do is to make sense of the topic by pinning it to the right picture and perspective, I hope. And in doing so, I also propose to deal with it in 3 ways. The first, in running of efficient virtual hearing. Secondly, promoting it. And thirdly, the combo of running and promoting it, both together. So firstly, running an efficient virtual hearing as not just a hearing, but an efficient one, according to your title, the title of the webinar today. And at the outset, it does not sound like an arbitration talk, but more like a technology strategy talk, because the cornerstone of any good virtual hearing would be good internet infrastructure. So I can vouch for the fact that it is not an equipment issue here, but I don't know why I couldn't get the camera on. So indeed, it manifests itself in real life. I was intending to actually fool the participants with a make-believe or technical issues that I would like to create, but it seems that a real technical issue arose right now. So I think that proves my point really here in what I'm saying, because the reality is we are all located in different locations where standard or quality of internet infrastructures, of course, they vary tremendously. And fiber optic connectivity, which is not widespread yet. Even in Singapore, we have fiber optic connection even at home, but it does not necessarily guarantee seamless and perfect connection as we are seeing right now. So for rule number 1, which is something out of the hands of the arbitration players, would be technology resources, the reliability of it, and so forth. Now, in running international arbitral virtual hearings, these will involve arbitrators, counsels, the parties and experts, and as well as service providers. So in turn, I would like to deal with a few of these salient points as regards the participants. Firstly, with arbitrators, there are some challenges here, not unsurmountable, but a real challenge here, whereby the tribunal is likely to be composed of arbitrators located in various geographical locations. Now, people lack the recognition of such an issue. Because technology makes many things easy, doesn't mean it complies with decorum and sensibility as well. Decorum because, for example, prelim meetings are to be conducted online. An appropriate time needs to be arranged, taking into account different time zones. If an arbitrator is in Singapore and hours ahead of, say, London, and just because the counsels located in London think that 3 p.m. is a good time for them to speak, does not mean that the tribunal would find it convenient to take the meeting at 10 p.m., which is nearly his or her bedtime. Now, the other aspect of practicability also is that where hearings are arduous and can typically take up to 7 hours per hearing day. An arbitrator is located in India, another in Singapore, the third in New York, and the hearing will say take place in Singapore starting at 9 a.m. For the Indian arbitrator, he or she needs to be up at 6:30 a.m., which is not too impossible, although it's just somewhat inconvenient. But the New York arbitrator, according to his or local time, with the hearing starting at 9 p.m. onwards until 4 a.m., the question is, would that make sense? So now, that is something that we need to bear in mind. You know? Agreeing to the agreeable time is certainly something that needs to be achieved. On the counsels and parties, similar to the above, time zone pose a major issue here because there are much more significant impact. It is not just about getting enough sleep, but the parties may object to their inability to stay awake, and as well as the issue of whether of their availability, therefore the opportunity to present its case. So this is very important because a couple of days ago, I was just involved in another major webinar talking about dilatory tactics by parties. So parties that is going to deploy dilatory tactics may then object to the hearing, saying that the timing of the hearing is inconvenient, it is hardship, and it does not give them a fair opportunity of presenting their case. Also, the obsession of, is there anyone else in the room? Please rotate your camera 360 degrees to be sure there's no one else in the room watching you. What are the materials on your table? What are these things written on the whiteboard on your office table, and so forth? And I think this kind of treatment towards witnesses can often be troublesome and to some extent condescending. And there may also be protracted delay due to objections or protests over the surroundings of the parties and as well as technical issues. On service providers, the software providers and vendors need to provide a solution that works and affordable. The narratives that because parties can save on travel costs, hence they should pay for the use of technology, in fact, it's not always a fair argument. The fact is, meeting face-to-face not only eliminates some major concerns, unlike when the hearing is conducted virtually, but it also underscores the importance of invaluable human contact, which can have a substantial impact on the cases, in particular, let's say, the advocacy of the case. Now, without going into the detailed argument on the business model of the technology industry, I think we're also in an era where users are increasingly reluctant to pay for the use of software. Many are still not prepared to invest in expensive hardware or additional software. And that could sometimes be an issue because I realized that for some hearings, certain technical requirements or software requirements expect the parties to have certain hardware which they may not necessarily have that. On the second point of promoting effective virtual hearing, I think at the outset, let me disclose that I am not at all a promoter of virtual hearing simply because I'm not a vendor or a software developer. I can only comment as a user, and I think that matters a lot. The short answer on the strategies to promoting effective virtual hearing is to ensure that the software works stable, robust, it uses minimal resources, both hardware and connectivity. It must be the parties need, of course, to log on 10 minutes beforehand to test the system. Should always do that. You never take it for granted that everything will work perfectly well. According to Murphy's Law, things can go wrong, it will go wrong. So it's really that short and simple. And also there are products that have been out there. They are in existence even before COVID. They are intended to be supplementary and they aid current business processes, especially for people who are located in different countries. Thirdly, to run and promote effective virtual hearing, the approach is to look at it as if it is a hybrid proposition, in my opinion. The world is in a temporary state of disruption right now in terms of the conduct of international arbitration and dispute resolution, rendering people not being able to meet face-to-face. It is not the end of the world, since we all hope that, of course, the situation will and must improve. It is far from the situation of the advent of technology invasion that we are rendered us all subservient to machines. Technology as an aid before and even during the pandemic has stepped in to provide assistance during the gap. And for the arbitration world, I don't think this will be a permanent solution to think that everything will go online from today onwards. But this is not to say that technology has no role. Let me just repeat that again. This is not to say that technology has no role or to suggest that people like myself object to technology. I think a hybrid approach should continue to exist even after a vaccine for COVID is found and our life returns to normalcy. Perhaps if there is anything to thank for the COVID is it has created an opportunity for us to try things out when we have been hesitating about it years ago. So I think in turns, this should drive further innovations to bring about cheaper and better technology out there. Now, I will just summarize this very quickly now, so that other speakers will get to speak too, so that we can have a discussion later on. Like I say, I have not been told the format of today's presentation, so I've just prepared a short note for this. I think in short, we got to understand that innovations are certainly welcome. And that despite the challenge and the sudden siege of this pandemic, I think we have also very quickly found a solution around technology. And but many of these solutions have already been around. And I prefer to take a middle ground and call for calm. I mean, let there be not too much of excitement or too soon with excitement about virtual hearings. And with some guidelines and rules that have been promulgated on all sorts of things on relating to virtual and online hearing, some potentially complicates the process of arbitration with more regulations. I think we've got to be very realistic about this, whether or not they bind the parties, and some requires the parties to adopt it. And some of these are also drafted in addition to existing rules. Whilst I thought that these intentions are all noble, they may also suffer the fate of eventually being forgotten and perhaps never even be adopted once life goes back to normal. So very much that, I think we got to look at things from various perspectives. And I guess, well, it doesn't sound, I mean, it is something that we need to weigh very carefully. And so whether or not it will become a long-term solution, probably yes, probably not, depending on which aspect or perspective one comes from. But I prefer to take the middle ground. So I'm happy to discuss this further during the remaining part of this webinars. Thank you.
Thank you so much.
Sir, now we move on to Mr. Nivesh Sharma, sir. Sir, along with the introductory note, I want to put this point further that there are a lot of securities issue when we talk about these video conferencing platforms. So how do we ensure that there is no security issue when we are conducting such conference or arbitration?
No, as far as the other panelists are concerned, they have correctly highlighted, Mr. Sandhu has correctly highlighted that limitation with regard to the examination of witness. And Mr. Steve has almost in entirety has told us all the limitation in the video conference hearing and all the benefits out of it. But I believe here in India is that lawyers and judges are very reluctant to change. I was listening to the webinar of one of the most prominent senior counsel in India. He said the lawyers and judges in the India are very reluctant to change. And what this pandemic has done to us is that it has compelled us to go for a change. So this pandemic has virtually compelled us to go for the video conference hearing. And most of the think tanks in India was brainstorming that how to reduce the functioning of the physical courts, that they should not be overcrowded. But we believe that we go into the India, the courts are overcrowded. Even the high courts, Supreme Courts are overcrowded. If the people are in the state of Kerala and they are placed in the Supreme Court, they're virtually required to travel. They have to take the flight. They're required to travel to Delhi to see their hearing. Now, since the virtual hearing has come into the picture, what it has done is that earlier before, we were thinking about it, how it will work, what will be the concern. Now we have come into the picture where we are running a system. There will be the trial and run. We are running on the trial basis. We make mistakes, and the High Court in the another notification make the changes that what the difficulties or the advocates are facing. So this is the one point. And secondly, I want to highlight is that whoever is primarily focused on the oral advocacy, any advocate it may be, with regard to the cross-examination or the final argument, he would not be the great fan or the supporter of the virtual hearing. Because when we cross-examine the witness, when we are examining the witness, we see his conduct, we see his body language, we analyze his body language, then we decide what our next question should be. And as far as the final arguments are concerned, we believe that oral advocacy begins from a moment when you enter into the court. When you enter into the court, what should be your body language, how you should conduct the oral advocacy, how you should put forward your point to the judge. And when you are into the physical hearing, you realize, you analyze from the expression of judge whether he is convinced from your argument or not. When he is convinced, you narrow your arguments, you don't proceed or further your argument. When he is not convinced, you analyze whether I should argue on another point or whether I should stop my argument. So with the virtual court hearing, we have this limitation that the oral advocacy, the part of oral advocacy has certainly been reduced. It is not as relevant as it used to be when we were in the physical hearing. And as far as the technological limitations are concerned, Mr. C has practically told us that he is unable to join us to the video. And these are the limitations. We have seen many cases when we enter into the VC, there are many advocates who are unable to join. So in India, we have thankful that virtual court hearing are limited in the civil proceeding are limited to the aspect of stay. First is pleading, then there should be a short argument on the stay. And we generally, the district courts are not proceeding with the cross-examination of the witness. They are till when there is an emergency, then only they proceed with it till the application of stay. They do not proceed further. So these are the limitations we face in the virtual court hearing, and we need to relook at how we should ensure that the witness should be examined as it was examined in the physical hearing, and how the relevancy of oral argument should be enhanced in the virtual hearing. And as far as the security issues are concerned, since I believe, I don't know, I practically say, since there are many think tanks who are proceeding with this issue that what software we should use, that no one should come into that, because virtually we are allowing anyone to enter into the courts. In the high courts of India and the district courts of India, media persons are entering without any valid ID card. Many persons are entering into the courts, even apart from the in-camera hearing. There are open courts. Everyone can enter into the court. So as far as the video conferencing is concerned, I don't see any limitation when a person should come or not. Every person should be allowed. He should see how the courts are proceeding. Every litigant or any person should be allowed to come. So I don't see any security concern in the immediate prospect. But since we are in the trial and run method, we may face a certain concern in after a few weeks. And then after we will see how the court can change their system.
Okay. Angad sir, I want to continue this point with you, because recently Thomas Valentine sir also joined us and talked about the various securities issue. So sir, are there any possible securities issue while conducting these arbitrations? And is there a fix or some precautions that we can take?
At the top of my head, there was a protocol, I think it was the New York protocol, that was formed for security and for data protection in international arbitrations. It was extremely voluminous. It gave situations on how data should be treated when, obviously, international arbitration, most of them are confidential in nature. So how would the data be stored? A lot of these on these webinar, on the softwares we're using, the deposition right from the beginning to the final hearings are all recorded. So now if it's confidential, if there's a confidentiality clause and parties agree to make the proceedings confidential, how will those recordings and that data be stored? Is a problem that would arise. Where a person is deposing on, there are massive patent arbitrations in which there's a lot of confidential information that's exchanged. It's proprietary information. So how will that data be secured? And anyone could access, if it could access the recordings, it would actually be a massive data breach. The Delhi High Court recently, in fact, under the new rules, created confidentiality agreements and specialized teams where the court would give permission to only certain individuals to access that data. So only the lawyers and one representative of the company would be able to file affidavits or even look at that evidence and then depose on it or to counter on it. for conducting video conferencing, there was the Seoul Convention as well that was passed. It's a lot of it I couldn't make a lot of sense of because I'm a little technologically challenged. It spoke about frames per second and proper firewalls, and it's extremely technical. For someone who has a keen interest in technology, I'm sure you'll be able to make more heads and sense of it than I could. But these problems are being addressed. They have been. It's an example that how now courts as well as different protocols and even the SIAC and the ICC are now taking out rules pertaining to video hearings. It is the future, and it is in fact the need of the hour. So there are, like I open by saying, there are a lot of these problems are being dealt with, and are being engineered very well dealt with, but it's all off the cuff right now. People are figuring it out as they go along. So with regards to confidentiality issues, I agree there could be some, but in that case, probably having a good case management group is where it would be helpful. And obviously the rules of the institution that's conducting the arbitration would have to be looked at to see if this problem has been addressed, how will the data be stored, and eventually how the data would be destroyed. So there could be an issue of confidentiality that could arise without a doubt with regards to virtual hearings. But those are problems that we will have to face at this stage, and there's no way around it. Hearings are not going to take place. Courts are not going to. I think Ghaziabad District Court started, and within a week there was, I think, multiple cases of COVID, and they had to shut down again. So these are issues that would be dealt with as and when we go along. And obviously, I know there are integrity issues that do arise, but as long as people are a little more straightforward with it, then they're not something that could really go to the root of a problem and derail the entire process. There are issues, but it's not something that makes the entire process undesirable, or rather the process of virtual hearing unsuccessful. So that would be my views personally on that point.
Right. Shaun sir, I have a question. My question is that usually institutional rules provide tribunals with broad procedural authority. So in a situation like this, is it a need for parties' affirmative agreement on the usage of virtual means for the speedy resolution?
Sir, along with this, let me club my question into this because it's on very similar lines. The LCIA rules Article 19(1) states of hearing in the manner of oral hearing, which can be converted into virtual hearing. So, sir, are there any differences in various rules which will prohibit and which will change the course of virtual hearings or the rules?
Right.
Thanks for those questions. I think on the first point on party consent, Kumar, you're right to point out that in most rules, the tribunal has quite a broad procedural discretion. And I think, or at least anecdotally, it seems to be that most people feel that the tribunal can, in fact, direct for a virtual hearing subject to specific rules, right? And that relates to Arusha's question, which I'll turn to in a moment. So I think the general view, or my sense, is that consent is not necessary. Although, of course, consent and cooperation does make it a lot easier to go ahead with the virtual hearing. And as Angad and Steve have noted in their presentations, a lot of this is a very fluid process. So it definitely helps a lot if the parties are on the same page. The parties are each trying their best to agree a protocol, to cooperate, and to make the virtual hearing work. On the second question, Arush, the specific rules. I'm not. I haven't sort of studied each specific set of rules for the position on virtual hearings, but I know that that there was some sort of ambiguity in relation to the ICC rules, right? Article 25, as I mentioned earlier, on one view, can be construed as requiring a physical hearing, right? Because there's a reference to an in-person hearing, unless the parties agree that that's not necessary. But the ICC Secretariat has since come out and clarified that an in-person hearing does not necessarily mean a physical hearing, but just like we are having an in-person session virtually, you could have a in-person hearing virtually as well. So I think, and again, I haven't studied all of the rules in detail, but I think the general sense is that most rules would permit the conduct of virtual hearings if the tribunal is of the view that it's appropriate in the circumstances.
Right, sir. Even Mr. Nivesh, sir, I also have the same question. Like, first capability is one, and second on the COVID situation with the corporate situation. There's no foreseeability as to when this restriction can or will be lifted. So the same question which I asked to Mr. Shaun Pereira is that should there be some institutional rules or which provides tribunal with broad procedural authorities for having a speedy resolution, and with parties affirming to have that a proper affirmative agreement to that usage of virtual means for the speedy resolution?
Since we have this session not only on the arbitration but on the efficiency of virtual hearing, I'll specifically highlight to this part on the litigation, not on the arbitration. I believe the part of consent has been dealt by the Delhi High Court in their recent rules, which are very clear on this. Until or unless there is an urgency of the case, you are not required to consent. You only need to satisfy the court that yes, I need this urgent. There is an urgency in my case, and I need the speedy hearing. Otherwise, my case or anything will be infructuous. Since consent is not required, provided you should serve to the other side. You should serve means you should state to the other side that this is my case. I have filed this particular writ petition or any other thing, any civil suit or anything, and you should supply the particular document to them. Then there is no consent required. And there are few pending cases where pleadings are complete. And the only thing which is required to be done was to hear both the parties. Until and unless now, if both the parties gives consent for the virtual hearing, court are limited to hear them. Court will not hear them at all. And now they have, in the recent notification, they have provided to me that these will be the cases. Both the parties, if they want, they can join and they can highlight whether they want to give their consent, whether they consent or not. And if both the parties consent, court will listen to them. Otherwise, the court will be limited to listen them and it should not listen them. And as far as the issue is concerned, we are analyzing in near future, we are not seeing that physical hearings will take place. And I believe courts now in the near future, maybe in a 1 or 2 months, maybe they'll change this approach and they'll come to the conclusion, they'll come with the notification that if only one party consents, both the parties are required to be heard through the video conferencing, where consent are not required. Maybe in the near future, we'll say where the consent is not required of both the parties. But as of now, the situation is unless there's an urgency, consent is required from both the parties.
Right, sir. Mr. NGO, Professor NGO, as you raised the question of integrity of the process, and I want to ask, isn't there should be a critical hearing to see how the witness reacts to a particular situation, like the body language, etc.?
Okay, first of all, can you don't call me NGO? You can call me Steve. Is that fine?
Okay.
You can,
okay.
Yeah,
yes, sir. Sure.
Yeah. Please, you can call me Steve. And yeah. So your questions about body language is something that I didn't talk about just now, but is exactly a point that I just wanted to say, even if I'm not invited to comment on it. I think one has got to be really careful about this. I think it's too early to suggest that new doctrines has been written just because of this COVID situation. I act as an arbitrator. And I will find it quite preposterous to judge a witness according to his or her body language. Because I think it is more than just body language. I mean, why should an arbitrator prejudge a person just because a person is flustered because his camera didn't work on the laptop? And as well as the counsel takes the opportunity to frustrate the person from the beginning by asking the person, like I said, to do all sorts of things, turn the camera 360 degrees and so forth. I think as a good arbitrator and a very experienced arbitrator need to be wary that the very basic tenets of it all, the parties must all be given a fair opportunity of presenting their case, so as not to give rise to a situation of allegations that there have been that the parties have issue a due process and that the parties have not been given a fair opportunity, as felt that the parties were under pressure and so forth. So I don't like to entertain these thoughts because as acting as an arbitrator myself, if I see that the parties are not, a party in fact, even in person, is not feeling comfortable about it. And put it this way, a trained counsel or a very experienced counsel will know how, will try its best to put witnesses under pressure, whether a face-to-face hearing or an online hearing. And so a good arbitrator must be able to pick that up and try to understand that arbitration is different from litigation. If you're talking about arbitration, there must be this understanding, and the tribunal needs to understand that this cognizant of the fact that we are here for a process that tries to resolve disputes throughout the facts of it all, and everything else different from a US-style litigation process. And so why can't we try to be open-minded as arbitrators to give the party an opportunity of presenting its case? So I don't know. Other speakers may disagree with me, but at least I can say that if you would appear before me as an arbitrator by camera or in person, I would try not to feel your body language should not prejudice your case. That would be my short answer.
Okay, sir. So we shall move forward with our concluding remarks.
Kumar, before that, if we have any questions from the audience, we are open for questions. You can type that in the chat, and we'll ask them on your behalf. Sir, before moving to the concluding remarks, I want to ask quickly to everyone: are there any strategies for an effect? That was the topic, that strategies for efficient virtual hearings. So are there any specific strategies that they use or suggest that one should follow in order to improve the quality of the virtual hearing? Let's start with Shaun, sir.
Thanks, Arush. I mean, I suppose I'll make 2 points. My first point, I will just kind of pick up from Steve's remarks. I mean, I agree fully with what Steve says when he says, you know, body language is a factor that a decision maker takes into account, but it can't be the be all and end all. You're always trying to assess the evidence based on a variety of factors, one of which may be body language and so on. But I think there's an important aspect of virtual hearings that you know, is worth talking about. And I think one thing that makes that is difficult to replicate in virtual hearings are sort of in-hearing interventions, right? So for example, when someone is making submissions, legal submissions, you know, if an arbitrator wants to interject with a question, I think that becomes more difficult because, you know how it is on video conference when people start talking over each other. It's more difficult for counsel to read the arbitrator. In a physical hearing, you know, you can kind of see when, you know, a person has a question, and then you can slow down and pause, and then there are timing issues. other interventions include, so for example, when there's cross-examination and you want to raise an objection to a cross-examination question that's being asked by the other side, that becomes a bit more tricky. When you want to try and control your own witness that you're cross-examining, you know, sometimes you have to, you need to try and kind of gently cut them off if they are going off topic. You need to try, and you know, you don't want to be seen talking over them, but you know, on VC, it's quite difficult to do that. Or for example, witness conferencing, expert conferencing, hot tubbing, right? If you have 3 or 4 experts in the hot tub and we are on VC, I mean, I could imagine that it may be a nightmarish experience if it's not properly controlled. So I think there's that element of in-hearing interventions that you know, it's something you need to think about when you're talking about virtual hearings. So that's the first point I'd make. The second point, and I think this is more directly addressed to Arusha's question on strategies for virtual hearings. I mean, I think one needs to reframe the way you look at a hearing, right? In a way. So when we're talking about physical hearings and especially international arbitrations, where everyone is kind of flying into a specific hearing location for a hearing, there is a strong incentive to have the entire hearing resolved in a single tranche, right? So a 5-day hearing, and we resolve all witness evidence, all submissions, so that there's no need to reconvene everyone and fly everyone back in for the hearing, right? And as a consequence, you know, sometimes I remember 2 cases where, you know, after the evidence was done on the second last day of hearing and the tribunal decided to have oral closings on the final day so that we wouldn't need to have a further hearing. And, you know, it was a crazy experience, you know, poring over the evidence from the previous 4 days of hearing and trying to help and package that into a, you know, a forceful oral closing on the final day. I mean, I would be happy if we didn't have that sort of arrangement. But the fact that you have a virtual hearing, it allows you to disaggregate the hearing process, right? So you could have witness evidence over 3 days, and then you have oral closings 2 weeks later. You could have a separate tranche of hearings, another time for, you know, expert evidence. You can sort of, so there are a lot of these advantages to kind of a virtual hearing, and that requires you to kind of take a step back from, you know, the typical way you think of hearings, and explore some of those advantages that can come with virtual hearings instead of just dwelling on the you know, the downsides, the risks, the inconveniences, and so on.
Yes, sir, that was really insightful. Now we go to Mr. Angad Sandhu, sir. Sir, any strategies or tips that you want to give for an efficient virtual hearing?
You know, I'll probably start by stating the obvious. I think having your basics, you know, your physical and your infrastructure is the most important thing. Like recently, what I've been doing is when I have my team working with me and some other people as well and seniors who we briefed, I take my iPad, I create a different WhatsApp group so that I can keep on talking to my colleagues and the senior at the same time while the hearing is going on. So, you know, having probably different breakout rooms is important, even in like international arbitrations, along with litigation as well. That's one strategy that I felt has been really, really helpful. Secondly, I would say, you know, detailed pleadings, because if you you know, make out your case and establish it in a detailed manner via pleadings, that reduces the role for oral arguments and oral hearings to an extent. I'm not saying it does away with it, but it does reduce it. So if you make it more, you know, memorial centric, that will obviously be one way that, you know, the inaccuracies of probably a remote hearing can be, you know, dealt with to a certain extent. Again, as Shaun said, you know, I mean, hot tubbing again is it's a slippery slope. Maybe if the witnesses could have their separate, or again, a breakout room where they could discuss the positions like point 1, point 2, point 3, and then confer with each other and establish what the baseline is on regarding those positions and come back. So for example, if on one issue the parties are so far apart, they can decide that the cross can only be limited to that one issue, and if there are issues in the middle where both parties agree, then maybe that could be done away with and a position could be accepted. I mean, you would have to have very collegial for a very collegial approach to establish that, but that's just a suggestion that probably could go a long way. And again, I did an arbitration in Paris last year that again was very similar to Shaun's. We were there for 5 days. We cross-examined 8 witnesses in 2 days, and then we had final closing arguments the next morning. And going through, and in this, again, the arbitrator had a memorial system. So there were responsive witness statements, there were sue rejoinders issued. And I remember just, it was probably 4 in the morning, and I remember just sitting there thinking, why did I decide to put myself through this in the first procedural order? Because going through, with responsive witness statements, the transcribed records. I remember when that arbitration ended, I did not leave my room for a day because it takes it out of you. And it's really demanding going through that entire procedure. And like I said, so, the strategies as such, would be, have the right infrastructure. You don't need much, probably just, you can have your phone, you could have a breakout room, define your roles as to, who's going to be the lead, who's addressing what points. Like, for example, if you have one senior for 2 issues and another senior, you are arguing on 2 issues, have clarity on that. And honestly, preparation, because this, with physical hearings, you can still probably, pick up a file or, quickly speak to a junior, pick up a judgment, and then, just wing it to an extent. The scope of that is reduced in virtual hearings. Let's be honest. If I'm screen sharing with you, or if I'm referring to a document, I have to know exactly where it is, or else it just derails the entire process. And that it's not an effective or an efficient hearing if there's a screen share happening, there's a lag, if I'm making a point and the document is not lining up, or if a junior opened the wrong document. So I think extra preparation from what probably went into physical hearing is what is required at the first stage. And probably, just have your basics ready, your breakout rooms, your sessions, and that's about it. And these are at the base, they sound very basic. I mean, they sound very like something that is very obvious, but even these small things, they go a long way. The judge is there for 5 minutes. He has to hear 20 matters more. If I'm talking about litigations here, if you can explain it to him effectively in 5 minutes, the chances of you being successful, the judge actually appreciating you, are much higher. I was before Justice Pratibha Singh the other day in the Delhi High Court. And I think we had a hearing for around about an hour and a half. But in that, luckily, we had prepared written submissions, we had given a written note, and we had a PPT ready. So as we are arguing, we had shared our screen, the PPT was running with our submissions, and it just aligned really well. So that made it very easy for the judge to give the order that we were looking for. If you make it, at the end of the day, they are of a certain vintage. If you make the process easy for them, it will help you in the longer run. Just these small things. And yeah, that's about it. I would say those would be my views on the exact strategies that would be involved in running an effective virtual hearing.
Thank you, sir. That was a really great remark. Make the process easy for them. It will be easy for you. Now we move on to Mr. Nivesh Sharma, sir, on the same question.
As far as all the speakers have correctly highlighted, what should be the strategy? I fully agree with them, especially with the Shaun, that we need to rephrase the word hearing. We need to broaden our understanding of the word hearing. Because as far as the physical hearings are concerned, we used to go into court, we present our argument, we see the judges is going along with us, whether it is a division bench judges is going along with us, whether it is a single judge, the judge is going along with us. Then we present a judgment to him, then after he dictates the order. And as far as the virtual hearing is concerned, and suppose you have one senior who is arguing, you have engaged the senior counsel, you have briefed him, and he's arguing the matter. And judge has put a specific query as far as the facts of the case is concerned. This is very much likely that senior counsel is not aware with that particular fact. Then you need to have the separate separate WhatsApp group or maybe a separate separate room for him, that any person who is aware with the factual metrics of the case, he can tell him that this is the present, this should be the answer of the what question the judge has asked to us. And earlier in the physical hearing, when 2-3 juniors were there and who were briefing the senior was there, if the judge put the specific query, we used to tell the senior counsel that this is the answer of the query, this is the fact, please narrate. The judge also used to go along with that. As far as the virtual hearings are concerned, taking judges along with you in an argument is very difficult. If your argument is not streamlined, you have not prepared beforehand that these should be the arguments, and if you can anticipate that these may be the queries which may follow from the judges, and you are required to answer these queries. If you are not fully prepared, then there is a possibility that judge may not go along with you and you will not get the favorable order. So therefore, the preparation, separate room, what Mr. Sandhu has highlighted is very important, and we need to broaden our understanding of the word hearing. Hearing, I believe now, is not a matter of the physical hearing. So therefore, earlier we used to do our pleadings were not very much detailed. If they are detailed in our oral argument, we add upon it. Now what we are required to do is, if we submit a written argument, it should be very detailed. It should be supported by the judgment. It should be very easier for the judge to understand. Earlier, although we used to file the written arguments, but to the oral hearing, we used to simplify our arguments. That these are our arguments. These are the judgments supporting in our contention. And in the right now in the written arguments, I believe we should simplify our argument, and we need to, as simply as possible, we need to give to the judge.
Right, sir. Let's move on to Professor Steve, sir. Sir, your views on this question?
Thank you, Arush. I would just I'll just try to answer this question on strategy on behalf of the underdogs. Who are the underdogs? Number one, we mustn't assume that those who participate in arbitrations are all from common law jurisdictions. I'd like to point out from my own experience, both representing assisting parties and as arbitrator, and also in my capacity as an academic. If we looked at situations in Southeast Asia, where I come from, Indonesia, Cambodia, Vietnam, and from some of my own actual experience, they don't understand the US style, the common law style of litigation style that has permeates arbitration these days. To them, they are alien to, it is all alien to them. And so as an arbitrator who arbitrates in such cases, we need to be very conscious of the fact that just because the witness doesn't appear comfortable doesn't mean the witness is lying, because English may not be his or her strong point. So if we are talking about international arbitration, we always need to be cognizant of this fact. If we cannot understand this and we cannot reciprocate to the parties in this situation, I think it is very unfortunate. So strategies. If you are representing a party coming from a civil law jurisdiction or a country where English is not their first language, I think as a counsel, the counsel would need to factor this into their strategy very carefully, especially when the witness is testifying via a video camera and a video camera that doesn't work, for example. I have been in a situation whereby as an arbitrator, a non-English speaking counsel, who needed the assistance of a translator. One simple question that could have been answered in a minute, or a yes or a no answer, it took 5-10 minutes just to clarify that, just to get an answer out of it. And the more we ask, the worse it gotten. So I think as a counsel then, if you speak English representing parties who don't speak English, you need to anticipate that. Take into consideration speaking through a screen in a remote location, hardware that didn't work, counsels for the other party putting in pressure, so you need to bear this in mind. So there's just one aspect of it. I mean, other than that, we also, when I mentioned about underdog, I also very briefly touched on the point that not every parties are experienced in arbitration, downright even to counsels, downright to even new entrant arbitrators. So depending on whose side you are on, whether or what role you are playing as a counsel, or you are an arbitrator, you're an expert, or you are the party that has been cross-examined and so forth. This all has to be taken into account. You need to strategize that, and that the tribunal should know beforehand. It depends on the rules. I mean, it depends on the rules on how to do this. I mean, I can't give a quick answer now. I mean, we did this short period of time and we did this short webinar. So this is what distinguishes an experienced from a non-experienced person. So I hope this will be a food for thought on this Sunday evening for everyone who is listening in. Feel free to ask any questions if you have. Of course, obviously, I can't answer this question. Feel free to email me. Some of you probably know me, or if not, you can email the organizers. I think myself, including other speakers, would probably be happy to answer more of your questions. Thank you.
Sure, sure, sir. I believe we have one question right now. That is from Bhavya Gupta. So let's take that. Kumar, would you like to proceed?
Yeah, sure. So, as per the question, he's asking that as per section 18 of the IACA states that each party shall be given a full opportunity to present its case. This includes the party's right to properly respond to the opposing party's submissions, evidence, and arguments with its own. The violation of this is ground for challenge under section 34, subsection 2, clause A, part 3, and 48, subsection B of the IACA. So the question that arises in his mind is whether a virtual hearing accords the party a full opportunity to present its case or not. This question is directed to each and every panelist. So anyone who wishes to speak first may go first.
Okay. Firstly, I think when you read a set of rules or you read any statute or any legislation, it has to be read harmoniously. In most arbitration rules, especially under the SIAC, IACA, there is a vast overriding power given to the arbitrator regarding the conduct of proceedings. Now, it's very easy. I think when you look into the background and the reasoning for giving the party a chance to respond to the evidence and the arguments of the other party, it doesn't necessarily mean physically being there to respond to those. It means a mechanism in which you can give your grievances, your defenses, your arguments, and to be able to fully dispute the claim put forth by the other side. If you can do that effectively via a remote session, which is now what is happening, then it doesn't mean that an opportunity wasn't given to meet the evidence. Or an opportunity wasn't given to meet the person's case. If you make your case out and you're given a hearing, being there physically present doesn't necessarily negate the entire proceedings, or maybe a ground of challenge. And especially if in the conduct of arbitral proceedings, mostly consent is taken of the parties. So if the parties have already gone forth and consented to carry out the conduct via video proceedings, and subsequently saying, raising a ground for a challenge that this hearings didn't take place physically, and hence it's a violation. This rule is quite absurd, and I don't think any court where it's challenged would even look into such a question. But again, when you would say meet your case, or you say to properly counter, it doesn't necessarily mean via a physical hearing. It could be a remote hearing. A lot of arbitrators don't even carry out oral. I mean, in certain cases, they don't even carry out oral hearings. It's all memorial based, and probably a closing argument, and that's it. So it's just you have to read these sections and legislations holistically, and you also have to apply them practically. Is what I would my inputs on the topic, on this question would be.
Professor Steve, do you have anything? Okay.
Yeah, I would just very quickly add to that. I may not touch on the IACA since there are other experts here who are in the better position and qualified to speak on to interpret the IACA. But put it this way, there is this thing called due process paranoia. Arbitrators, especially experienced arbitrators, are also wary of the fact that whatever they do, they are conscious of the fact that they want to render awards that are enforceable at the end of the day. So that will be another discussion. Now the point is this: it is always common for parties to raise the objection or the argument that they have not been given a reasonable opportunity of presenting their case. Is this unreasonable? I don't think it's unreasonable. It's not. categorically unreasonable unless we look at the context of this objection or this issue itself. But I think the basic tenet and the fundamentals of arbitration is that the tribunal should give the parties a fair opportunity of presenting their case. And whilst other speakers may have talked about trying to draw parallel comparison between online, offline, and no oral hearing, some arbitration rules states that parties, the tribunal cannot impose upon the parties on the documents on the arbitration unless the parties agree to it. So again, with all these things in mind, in front of the arbitrators need to consider this. I mean, this is all I can say in short, in response to this question.
Thank you, sir.
I've just got a quick comment. I mean, I would echo the views of Angad and Steve. Fully agree with what they've said. But, so there was this interesting case I came across, Sino Dragon and Noble Resources. It's the case of the Federal Court of Australia. A challenge was actually made to an arbitral award that, and part of the evidence was taken via video link from witnesses in China. And the point, and it was precisely challenged on this point because there were issues, technical issues with the video link. The connection kept dropping. The argument was made that, look, this impeded that party's ability to present their case, right? Because they just simply were prevented from giving that evidence. And I think the court said, consistent with the remarks Angad made, look, the fact that you're giving evidence or conducting the hearing by video link does not in and of itself affect your ability to present your case, right? And if the technical or or technological impediments are so high that could possibly constitute a breach of your right to present your case, but on the facts of that case, the court said that simply wasn't made out. So I think one also has to bear that in mind. The use of video hearings could raise technical issues like this, but I don't think it's anything experienced or a diligent arbitrator or counsel wouldn't be able to work around to ensure the integrity of the process.
Right. Nivesh, sir, do you wish to add something to the point?
Yes, not only I just want to add, not only limited to this rule, I guess all the legislation in the entire world which follows the due process, that this is the part of principle of natural justice, that everyone should get the opportunity to present his case effectively. Now, this is the subject matter, whether the video conference hearing is effective or not. But I believe what most of the courts are following is video conference hearing is the effective hearing. Not only the video conference hearing, but also when you got the opportunity to present your case in the written form of submission, that is also the effective hearing. And as far as if no prejudice is caused to you, then you cannot come with the argument that I was not allowed to present my case effectively through video conference hearing. That's it.
Thank you so much, sir. So this was all as the questions from the audience. Arash?
So looking forward to that. Thank you, sir.
It's been an absolute pleasure to be a panel member with the other members on the panel. I mean, thank you for your insights, and obviously the organizers, Shaun, Nivesh, Steve, thank you so much. It's a great Sunday afternoon, and it was a pleasure talking to you and discussing these ideas with you.
Yes, thank you very much. Really appreciate you organizing this, and it was a real pleasure discussing these issues with everyone.
Thank you so much, sir.
Thank you so much to the host and specifically the panelists. We had a great brainstorming session in the Sunday evening, and hopefully the participants will also learn something new from this session. Thank you so much.
Thank you so much, each and every one of you, for coming on board with us. Thank you, Nivesh sir. Thank you, Steve sir. Thank you, Angad sir. Thank you, Shaun sir. It's a pleasure hearing from you guys, and we hope that we'll again conduct a session and an interactive session with all of you, and we'll
In
again be
regards to the feedback link, it will be provided to you via mail. Don't worry about that.
okay. So we hope that later, sooner, we again have a session with you all, as it was such an enriching session to know about various aspects of virtual hearing, different aspects which we were unaware of, and it is really glad that you guys took out your precious time to enlighten us with these particular aspects. Thank you so much. So let's call it a day.
Sorry. Yeah, sorry. Thank you so much. I was having some technical issue. Okay, thank you so much to the organizer for organizing this. It is, by the way, it is a National Day in Singapore. So to any Singaporeans present here, wishing all of you a happy National Day as well. Thank you very much.
Same to you, sir. Thank you. Thank you. Thank you. Thank you guys for joining us. So let's call it a day. We are ending the session. Thank you.